Welcome to this next lecture on Chapter 4 of my book, Artificial Intelligence, Neurodata, and Society, Law at the Edge of Cognition, available on the Bloomsbury website for pre-order, today's date anyway, by me, Dr. Mark Leiser. Chapter 4 takes the investigative pressures from the previous lecture and brings them into the courtroom. Here the stakes change a little bit. A police lead may remain provisional, but evidence contributes to conviction, punishment, and the public attribution of guilt. AI-interpreted neurodata arrives with an unusual form. It's produced from EEGs, fMRIs, or related signals, but its legally relevant meaning comes from a model that labels recognition, deception, awareness, or intent. The chapter's argument is not simply that the science may be uncertain. Even a statistically robust output can remain legally unacceptable if it cannot participate in the cumulative structure of a fair trial. Courts remain more than predictive performance. They require reasons that can be understood, challenged, and evaluated within shared legal standards. This lecture therefore asks whether cognition can become proof without allowing technical authority to displace adjudication itself. The chapter's ambition is therefore jurisprudential. It asks what evidence must be like before a court may legitimately use it to condemn a person. AI-interpreted neurodata occupies what this chapter calls an evidentiary twilight. It's not conventional testimony because no human declarant directly authors the claim. It's not ordinary physical evidence because the relevant proposition does not exist independently in the signal. The system constructs meaning through experimental elicitation, pre-processing, and modeled association. An expert may present the results, but the expert cannot explain why this defendant, with these inputs, produced this classification at this moment in terms that map onto legal reasoning. That is why legal acceptability differs from scientific validity. A technique may identify stable correlations under controlled conditions, yet remain unsuitable for adjudication. The trial is not a laboratory. Its legitimacy depends upon participation, equality of arms, and the opportunity for rational disagreement. The question is whether computationally inferred mental state can enter that institution without bypassing the very process that makes a verdict lawful. The deeper issue is whether the evidence can enter a shared practice of accusation, answer, and justification. The comparison table you see here isolates four frictions. Traditional evidence usually has an identifiable source, a recognizable process of creation, a mode of assertion, and a pathway for challenge. Neuroevidence begins as an abstract physiological signal, is elicited through a protocol, acquires meaning through computation, and enters court through expert translation of an output that may not be directly inspectable. Its epistemic status is probabilistic, and its contestability limited. The chapter here responds with the idea of adjudicative assertability. Evidence must communicate reasons, invite challenge, and operate within shared norms of rational persuasion. Where a model's cognitive claim cannot be translated into those forms, the problem is adjudicative untranslatability. This is sharper than a general demand for explainable AI. A technically detailed account of architecture may still fail to explain why the output should count as a legally meaningful assertion of knowledge, intention, or responsibility. Adjudicative assertability, therefore, connects evidence law to constitutional legitimacy. A claim that cannot be meaningfully answered cannot simply be repaired by statistical sophistication. Scenario 7 in this chapter pushes the evidentiary ambition to its breaking point. The classifier reports a pattern consistent with normative awareness of illegality. That phrase sounds precise, but it compresses a contested legal category into a neural label. Criminal law ordinarily infers mens rea from conduct, context, explanation, and the elements of the offense. The process remains public and revisable. The model instead compares the defendant's activation pattern with labeled training data and present statistical resemblance as detected cognition. A heat map and confidence band give the output an aesthetic of certainty. Yet, who authored the accusation? The programmer did not decide the case-specific inference. The expert translates rather than reasons through it. The model cannot be cross-examined. The court receives the result without participating in the process that produced it. The scenario warns against recoding legal judgments as neural fact and treating modeled similarity as an answer to a normative question. Normative awareness smuggles a legal conclusion into a training label, and returns it as discovery. The traditional self-incrimination line distinguishes compelled physical material from compelled testimonial communication. Fingerprints, blood, voice exemplars usually fall on one side, speech, confession, and the contents of the mind on the other. NeuroAI destabilizes the line because brain activity is physical in origin, but valuable precisely for the mental meaning attributed to it. The raw EEG trace does not incriminate. The classifier's claim that the subject recognized a weapon or understood wrongdoing does. United States doctrine, for example, from Scherber and later biometric access cases asks whether the compelled act communicates knowledge. European law under Article 6 focuses strongly on the will and participation of the accused. P300 in functional MRI procedures may require the subject to attend to stimuli and engage cognitive faculties. So the chapter's functional question is therefore compelling. Should constitutional status turn on the biological origin of the signal, or on the cognitive claim the state extracts from it? NeuroAI forces doctrine to confront the purpose behind the distinction, protecting the accused against compelled participation in the production of incriminating mental meaning. That fair trial problem extends beyond compulsion. The defense must be able to inspect and challenge the material carrying accusatory force. With NeuroAI, counsel may question an expert about error rates, validation, system design, but still fail to reach the inference performed in the individual case. Training data may remain proprietary. Feature engineering may be complex. The model's internal representations may resist explanation even to its designers. This creates an accusation without an accuser. Equality of arms weakens because the prosecution wields a technical artifact whose authority the defense cannot reproduce or rebut on equal terms. So this chapter's demand for adjudicative assertability is therefore institutional, not cosmetic. Disclosure of a model card or source code alone may not make the cognitive claim legally intelligible. Courts have to ask whether the evidence can be translated into propositions, assumptions, and reasons that the parties can genuinely contest. The algorithm computes. It does not argue. Without access to the inferential pathway, formal cross-examination risks become theater. The defense questions the spokesperson while the operative accusation remains untouched. In this chapter, you find Scenario 8, which reverses the direction of use. The defense offers a scan that detected no pattern associated with premeditation or deliberate comprehension of wrongdoing. It argues not that the model proves innocence, but that it preserves reasonable doubt. The inversion is tempting, yet structurally unstable. Non-detection is not neutral. It reflects training data, thresholds, task design, and the categories the model was built to recognize. The system may fail to detect deliberation because the signal is noisy, because the defendant differs from the training population, or because legal intent does not correspond to a stable neural signal. Jurors may nevertheless treat algorithmic quietness as proof of absence. The burden of proof remains formally with the prosecution, while the psychological burden shifts towards competing technical authorities. The scenario shows that defense use does not cure the problem. Both parties invite the court to replace normative judgment with moral credibility and to treat silence with a classifier as legal meaning. That symmetry is important because procedural legitimacy cannot depend upon which party finds the opaque model advantageous in a particular case. Chapter 4 does not reject neuroscience as such. Carefully validated evidence may assist courts in questions of capacity, impairment, or treatment. The chapter's objection concerns AI-generated cognitive classifications that cannot satisfy the communicative and contestable conditions of adjudication. All legal proof uses inference. The distinctive danger is that NeuroAI relocates inference from a public form of reason-giving into a technical system operating upstream of the trial. Courts receive confidence without accountability, visual authority without an answerable author, and a claim about a mental state that neither party can reconstruct. Scientific reliability is therefore necessary but not sufficient. Admissibility must also turn on procedural intelligibility. A legal order that allows private model design to determine the meaning of cognition relinquishes control over judgment. Do not forget to check out the next video in this series, where we turn to Chapter 5, Architects of Control, and examine how corporate NeuroAI engineers behavior for profit. Computational system may inform judgment, but it cannot substitute for the court's obligation to reason.